Zimbabwe's Senate has passed a constitutional amendment bill that gives the president powers to appoint judges and remove the requirement of a running mate in presidential elections. The bill also proposes the extension of a women's quota system, which provides for the appointment of 60 additional non-constituency female members of parliament. A provision for 10 seats in parliament for the youth has also been included. Only 10 senators opposed the bill during the vote, with 5 opposition senators voting in favour of it. Well, for a little bit more on this story, we're now joined via Zoom by Dr. Thompson Chengeta, who's a constitutional law expert. Thank you so much indeed for joining us, and welcome to the programme.
Thank you very much, Peter.
All right, so you are a constitutional law expert, international law expert. What's your immediate reaction in hearing that Zimbabwe's constitution has been altered, and I believe there's as many as 27 amendments?
The immediate reaction, Peter, is that this is a very unfortunate event. Mainly because of perhaps 2 reasons. The first major one being that these are illegal amendments. The procedures that ought to be followed when you are making the sort of amendments that have been made, you need to follow certain procedures which have not been followed. That is very, very unfortunate given the nature of the Constitution as the soul of the nation.
All right, let's talk a little bit about that. When you say that they're illegal, why is that? I mean, given that the Senate sat, debated, voted, and passed the law. So
there are specific provisions which I would want to refer to, particularly Section 328, that deals with certain procedures that you need to follow when you are making amendments, particularly regarding amendments that affect term limits of public officers, in this particular instance, that of judges. So you would note that the amendment regarding amendment number 2, it's also sought to increase the retirement age of a judge from 70 to 75. And consequently, that is increasing the term limit of that particular judge. And in terms of the section that I have referred to, for you to be able to do that, not only do you need to have a 2/3 majority, you also need to have a referendum, a public referendum, which the government of Zimbabwe is actually sought to avoid. So in this particular instance, if the president of Zimbabwe, President Mnangagwa, is going to sign this particular bill into law, the Chief Justice or the judges that will be appointed in terms of this amendment will be tainted forever with illegalities.
So the law is quite clear then. I mean, it makes one wonder how they could have proceeded given these flaws.
Indeed, Peter, the law is very clear on these circumstances. Unfortunately, this is one of a clear example where the government of Zimbabwe is clearly showing that it is not bothered by the rule of law. The Constitution, as you know, is the supreme law of the land. It is the soul of the nation. That surely when it comes to procedures and rules that are laid in terms of the Constitution, the government ought to abide by those. But the flagrant violation of those procedures, and this is not the first time. The first when they attempted to do the same thing in regard to amendment number 1, which also sought to do the same thing of giving the power to the president, for example, to appoint judges without going through the process of interviews. The Constitution, again, was being violated. And lucky enough, in those circumstances, the Constitutional Court ruled that the amendment which they tried to introduce was illegal. And you'd think that the government would have learned its lesson by then. But you see, again, amendment number 2, which is clearly linked to the first amendment, number 1, coming through again the back door, them again flouting procedures that actually ought to be followed when you're amending the Constitution. And these procedures, Peter, which I referred to, which we say they need to be followed when you're amending a Constitution, they are there for a fundamental reason. A Constitution is not just like any other legal document or any other law. It is the supreme law of the land that ought to protect, especially these excesses when it comes to exercise of executive power. The purpose of Section 328, if you look at it, it is to guard against the idea where people, for self-interest, may end up amending Constitution to self-serve. But when you are having now a government which is not willing even to abide by that particular provision, it is really problematic.
So in reality, this law can't exist, and even if the president signs it, it lacks constitutional muster. Is that what we're saying?
Exactly. The unfortunate thing is I would want really not to say give the benefit of the doubt to the government. I think they know. They actually do know that what they are doing is illegal. But it is perhaps the shamelessness, the we don't care attitude. We do as we please. Our word is the law. That is actually what is transpiring. Unfortunately, what we are witnessing now, Peter, these illegal amendments you are seeing, these unfortunate retrogressive measures that are happening to the Constitution, they are not coming from the air. You can actually trace them back to when we started mutating at the Constitution in 2017. Remember, I think we had that other conversation when we talked about, the coup in 2017, and we discussed the implication that once you start going that route, it's a slippery slope. There is no stopping. So all the recalls, the illegal recalls which are happening in the parliament, and now the illegal amendments which are going, they're just a manifestation that once you have tended your hands, once you have gone on the route of illegitimacy. Because here's the thing, when you are violating laws as a leader, when you are going on the route of being illegitimate as a leader, what happens is that in that process, you have comrades who are helping you to do that. And now when it comes to the circumstances where they also need to be saved by you from certain scenarios which they face, this will also cause you to continue now violating the law, which is very an unfortunate thing that is happening in Zimbabwe.
What could be the possible consequences or any concerns that you might have where the president has the power to appoint the Chief Justice and the Deputy Chief Justice?
Well, I think already the problem which we face, Peter, is about the issue of the independence of the judiciary. Separation of powers. When you're talking of checks and balances, the excesses of the power that are exercised by the executive, you are having your hope in the judiciary. But in Zimbabwe, let me say this to begin with, we are already having a problem of having no judicial independence as far as courts are concerned. Now, the impact of what is happening perhaps is only that it's going to make things worse. Because once someone knows that they've been put in a certain place through cutting corners, not following procedures of the law, surely that individual, someone may argue that they are going to try and act at the pleasure of the person we have done them that favor. So I've heard arguments, for example, Peter, where they say it is not a new thing. If you compare to other countries, say the United States, of course, judges are appointed by the president. It is true. It is true, and we had those circumstances before we had the 2013 Constitution. But that is not the best. That is not the best situation. If we compare to what happens in South Africa, if we compare to what happens in Kenya, countries which actually we emulated as far as those provisions are concerned, that when it comes to those who occupy the important seat of the judge or the judges of the higher court, there is, of course, that need of scrutiny of those individuals, so that the public may also have confidence in the individuals who are dispensing justice. I've heard arguments, Peter, where people say, but well, what is the necessity though if a judge has been sitting on the bench for those many years and now they're just being promoted to the Supreme Court or the Constitutional Court? Do they need to go into a process again of being interviewed? Some of them even calling it's an embarrassing situation. And we emphasize that is not the point. The point is not to embarrass anyone, and it does not necessarily mean that once someone is a judge or once someone has been appointed to be a judge, it means they've been a good judge. The time they've been doing, maybe they were doing a terrible work, maybe they were being corrupt. So the purpose of these public interviews is to also allow or make sure that those who sit on the bench, if they have hopes, of being appointed at a certain point in time or being elected to a higher court, they will know that when it comes to that appointment, it won't depend only on the executive. It will depend also at the whole nation seeing the process in a transparent manner. So the amendments, in taking away that process, it's really a retrogression and a sad day for democracy and constitutionalism in Zimbabwe.
Is there a remedy for citizens, opposition parties? I mean, can they say, take it to court and say, you can't pass this law, even though it's Parliament that is signing it into law?
Of course, there is that option which we hope will be exercised. Remember, I gave reference that the first amendment, number 1, was actually successfully challenged in court, and it was ruled that that amendment, that constitutional amendment that sought to give the president the power to appoint judges without having them to go through public interviews, was actually held to be an illegal because it had failed, just like in the current circumstance, to follow the procedure in terms of Section 147 of the Constitution. So the first option is to say, yeah, we can have to, or we do have to challenge this in court. But of course, this is not being, deaf to the reality or to be blind to the reality, to the fact that, given the circumstances that what have been happening, especially in Zimbabwean courts when it comes to these issues, that it may be already a delayed match or something that is already decided. But I wouldn't want to cast aspersions on that option to say we need at least first to challenge that in courts. The importance of doing that is that when it comes to regional and international, remedies, which I think they should also be pursued in these circumstances, is that you need to exhaust local remedies. And local remedies, we are referring to judicial remedies within your country, to say we have this situation which we believe contradicts these fundamental human rights, and as such, we have approached our local courts, and our local courts have failed us. So you cannot be able to make that claim unless you actually pursue that domestic remedy. So as a first legal solution, which I would also recommend, and I guess many people support this even so, with a little reservation, is to say this has to be pursued in the courts to challenge this illegality. The second aspect, of course, you cannot divorce this from, the citizen movements, the citizen participation. This is one of the things which gives real legitimate reason to protest against this kind of illegality. Unfortunately, as I'm suggesting issues of protesting or demonstrating against these illegalities, I'm not blind also to the fact that the demonstrating space in Zimbabwe has been consistently closed, with the police, with the security agencies being brutal to those who even, participate in any demonstration, even so, again, for just cause.
Dr. Thompson Chengeta, we're going to have to leave it there. Thank you very, very much indeed for your insights on these amendments and what they mean for Zimbabwean law and democracy. Thank you so much for joining us.
Thank you very much, Peter.
All right, that's Dr. Thompson Chengeta, who's a constitutional and international law expert, speaking to us from London about what's happened in Zimbabwe. The Senate passing some amendments to the Constitution, which, amongst other things, gives the President very powerful ability to appoint the Chief Justice, Deputy Chief Justice, and a lot of it doesn't have to be public.